Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if an employee faces criminal charges for conduct committed in the workplace. Can the internal hearing occur before the criminal case concludes? Now, as you are aware, certain workplace misconduct also qualifies criminal offences, with theft, fraud and assault being prominent examples. When an employee faces allegations of such misconduct, it is not uncommon for employers to pursue criminal charges as well. Now, this situation poses a dilemma for the employee who might worry about self-incrimination in the criminal case while providing evidence during the disciplinary hearing. Consequently, employees frequently request a postponement of workplace discipline until the resolution of the criminal matter. Unfortunately, these delays are typically not in the best interest of employers. A recent decision by the Labour Court clarifies that employees cannot avoid or delay disciplinary action as a result of criminal prosecution. In this case, the employee was charged with misconduct in connection with 19 payments made to certain providers. The essence of that charge was that he failed to follow the internal control procedures of the employer. The employer amended the charge sheet later on by adding two new additional charges of fraud. The employer also laid criminal charges with the South African Police Service in respect of these additional charges. Now, the employee was not happy with that, and he complained about the laying of these criminal charges against him. He alleged that the laying of these criminal charges compromised his constitutional right to a fair trial. Furthermore, he argued the laying of criminal charges against him in the midst of a disciplinary hearing could also compromise his right to remain silent in the event of an arrest or detention. But the employee's main concern was that the evidence that he might give at the hearing could be used against him at the criminal trial. And furthermore, it would be difficult for him to testify freely at the hearing on account of fearing giving self-incriminatory evidence, which may infringe on his right to fair labour practices. The employee therefore approached the Labour Court on an urgent basis, asking the court to postpone the disciplinary hearing pending the finalisation of any criminal proceedings that may be initiated against him. Alternatively, he sought an order for the withdrawal of the additional charges so that the disciplinary hearing would proceed and determine the initial charge only. Now, the crux of the issue that faced the Labour Court was whether the rights enshrined in Section 35 of the Constitution entitles an employee to protection from a disciplinary hearing where this employee faced both disciplinary charges and criminal charges for the same alleged misconduct. This is what the court said. The court held firstly that whether it can interfere in a disciplinary process will depend on the facts of the case, and this can only take place where there is a miscarriage of justice or where prejudice might occur. The default position of the court is to allow proceedings to continue uninterrupted until they are completed. The court found that employees have a choice as to whether they exercise their right to remain silent. Finding employees guilty in employment and criminal matters is not dependent on the employee's election not to present a version, but rather on the state and the employer's ability to prove their respective cases. Now, the court also considered that during a disciplinary hearing, the employer must prove the employee's guilt on a balance of probabilities and not beyond reasonable doubt, as is the case in criminal matters. Furthermore, even if the employee gives self-incriminatory evidence during the disciplinary hearing, same may not be automatically admissible at the criminal trial. The court held that the employee was further protected by the possibility of a discharge should the state fail in its onus to prove the allegations of an offence beyond a reasonable doubt. The court found that a guilty finding or a not guilty finding at a hearing has no bearing on the state's obligation to prove the employee's guilt beyond reasonable doubt at a criminal trial, and therefore all the constitutional rights provided for in Section 35 of the Constitution will remain intact and uncompromised by any evidence which may be given in a disciplinary hearing. The court underscored that the employer consistently possesses the right to uphold discipline through a just and fair disciplinary process. And similarly, the police are obligated to investigate criminal behavior irrespective of the complainant's identity, including cases where the employer lodges the complaint. Consequently, the court determined that the employee failed to establish any valid grounds warranting the postponement of the hearing. So, in conclusion, this case makes it clear that employees can still be disciplined by their employers even if they are facing criminal charges for the same misconduct. That brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. As always, if you have any questions or comments, we would love to hear from you. You can find us on social media, or you can email me at veerpeer@massconsulting.co.za. Till next time, bye-bye.